Farivar is a senior tech policy reporter at Ars Technica, and he joins us today. Hi there. How are you, Cyrus?
Good morning. How are you?
I'm very well, thank you. I find the topic of this book fascinating because it's something that I've talked about before with other people, and it basically revolves around the rule of law versus where we're going with technology. Why don't you take it from there and explain a little bit more?
Yeah, so the book covers basically the last 50 years of surveillance law in America, going back to a case called United States versus Katz that involves a guy in Hollywood, in Los Angeles, who liked to gamble using public payphones on Sunset Boulevard, and ultimately was caught there doing so. But in the Supreme Court, in that 67 case, overruled the lower court's decision, finding that this guy, Charles Katz, had a, quote, reasonable expectation of privacy and could not be surveilled by the police unless they had a warrant. Taking us all the way up through to the present day, there's a case that's pending before the Supreme Court right now that's called United States versus Carpenter, that involves a group of guys that were robbing cell phone stores and Radio Shacks in Michigan and Ohio some years ago. And through a regular court order process, a lesser standard than a warrant, without a showing of probable cause, the police were able to obtain over 120 days of cell site location information, essentially where this guy Tim Carpenter's phone had been seen, which is sort of a proxy for where he had been seen. And it showed that, yes, his phone was seen not only at the scenes of the various crimes, but also it showed a pattern of behavior that had nothing to do with, his alleged criminal activity. It showed, when he was at home. It showed when he was at church. It showed when he was at his grandma's house. It showed when he was at other residences overnight that were not his own.
The other interesting aspect to me right now, and this is, once again goes to the legal aspect, is that police officials, authorities want to be able to get into a cell phone, and the phone is so well encrypted that, barring the company that manufactured the phone or sold the phone, there's no way to get into it, and the companies are loath to be able to pop open these phones.
Yeah, that's partly correct. So what you're talking about is Chapter 2 of my book, which details the story from just a couple of years ago, where there was a famous showdown between the Department of Justice and the FBI on the one side and Apple on the other side. And this was in the wake of the tragic San Bernardino terrorist attack in Southern California from December 2015. And yes, there was a phone that was found at the scene there that was used by this guy, Syed Rizwan Farouk, who was the dead terrorist, and the government really wanted to get into the phone. It's easy to understand why. And they said that they were not able to otherwise get into the phone. And so they went to a federal judge, a federal magistrate judge in Southern California, and they got a court order that would have ordered Apple to re-engineer the software on the phone so that they could get into it. Ultimately, we don't know whether the government's arguments were persuasive because the day before, something like 12 or 16 hours before that hearing was supposed to take place, the government came back and they said, well, actually, we found a company that can help us get into the phone. So the legal question is still unresolved. And I just say that you were partly correct a moment ago, just to say that, what the FBI and the DOJ generally call this problem, they encapsulate it in this phrase, going dark. And they say that, as you were talking about, that it's difficult for them to get into locked devices. However, the FBI does currently maintain a division that works with companies. There's a notable company called Cellbrite that is a digital forensics company, and they actively work to get in phones with some decent amount of success. They don't have a perfect success rate, but the fact that, in the San Bernardino case, that the FBI ultimately was able to get into the phone, I think shows that, the devices that we carry are not 100% bulletproof.
Interesting, too, that you should touch on this, because there are now a couple of phones that use facial recognition to actually unlock the phone, which leads to my question about facial recognition and the law. How much or how little can authorities use that when they're looking for somebody, say, in an airport or a bus station or a train or even in other public spaces?
Yeah, so that's a really good question. So the Supreme Court has said in a different case that I also read about in the book that there is no, I talked a moment ago about this reasonable expectation of privacy. There is no reasonable expectation of privacy under our current law when you are in public. So the police, just as a regular police officer could, take a picture of you or write down notes of you if they see you walking down the street, the legal theory goes that they could use a facial recognition device. Very soon, I would bet this year or next year, there's going to be, just as there's a prevalence of body-worn cameras right now by police departments around the country, those devices very soon are going to have facial recognition capability. And there already is a government database of most of our faces. If you have a driver's license, if you have a government-issued ID, if you have a passport, the government already has a picture of your face.
Interesting stuff. Good read, by the way. Thank you very much for spending time with us today. We appreciate it.
My pleasure. Thank you.
Cyrus Farivar, Senior Tech Policy Reporter at Ars Technica.